Hello and welcome to the Kenneth Vercammen Law Office Legal Podcast, the NJ Laws Tube. Let's see, this is a pre-recording for the New Jersey Institute of Continuing Legal Education seminar, handling drug, DWI, and serious motor vehicle cases in the municipal courts. And we're looking at recent cases decided by the Supreme Court and Appellate Divisions. And let's say I was running during the summer, and I happened to run into a municipal court judge, and he says to me, "Kenny, I got to give a talk on the Crawford Decision." And he goes, "Well, what is exactly the Crawford Decision?" And I said, "Well, it was a major United States Supreme Court decision that bars most out-of-court statements and documents." And then in 2006, the New Jersey Appellate Division in the Berezanski case barred a lab certificate in a DWI blood case. So, what's some of the recent cases dealing with hearsay and Crawford? What about the eyewitness statements to the police at the scene? Let's see. Well, those are not admissible. State in the interest of J.A. Let's see. There, the court held that a statement by an eyewitness is not admissible as an emergency investigation statement. The court held the hearsay statements were a narrative of past events and made while neither the declarant nor the victim was in imminent danger. These statements were testimonial, and because the declarant was not produced as a witness or subject to cross-examination, the omissions of the statements violated J.A.'s Sixth Amendment right to confront witnesses against him. And that was state in the interest of J.A. 195 N.J.R.E 324, New Jersey Supreme Court. So what about statement to DYFS workers? Let's see. Well, a statement to a DYFS worker under an emergency isn't admissible. And that was State versus Buda 195 N.J. 278. The Supreme Court held the trial judge did not abuse its discretion in determining that the child's statements to his mother and the DYFS worker were properly admitted into evidence as excited utterances under New Jersey Rule of Evidence 803C2. The child's statements were not testimonials, and hence their admission at trial did not run afoul of the Confrontation Clause. Let's see. Well, obviously, shouldn't breathalyzer certificates be barred as hearsay? Obviously, there's no excitement in a breathalyzer certificate. Well, the Appellate Division held the Crawford hearsay rule does not apply to breathalyzer certifications. That's State versus Sweet 195 N.J. 357. There, the ampules testing certificates and breath testing instrument inspection certificates are hearsay statements admissible under the business records exception to the hearsay rule. Those records are also non-testimonial and thus admissible under the Confrontation Clause. What about alcotest certs? Well, the New Jersey Supreme Court in State versus Chun held the alcotest documents were not barred by Crawford. What about now? There's some other recent cases that don't deal with alcohol. For example, careless driving tickets and speeding tickets. The statute does not provide for a loss of license. Let's say, can a judge suspend someone's license where the statute is silent? And the answer is yes. A judge can suspend for a traffic offense. That's State versus Moran 408 NJ Super 412, Appellate Division 2009. The court rejected the constitutional implications and challenges to the point system and approves NJSA 39:5-31, which authorizes, without standards or limits, driver's license suspensions for willful motor vehicle violations. And that was State versus Moran Appellate Division. Let's see. Now, let's see. Occasionally, someone has a second offense. Let's say, and it's a oops, I did it again thing. So when they're looking at enhanced penalties for second offenses, Occasionally, post-conviction relief motions can be filed. Let's see, under what's now known as Rule 7:10-2. And where should post-conviction relief motions be filed? In the court of the original case or the pending court? And in State v. Schlatterwald, the appellate division said a post-conviction relief motion, PCR, should be filed in the municipal court in which the prior uncounseled conviction occurred. That's State v. Schlatterwald. There they held a defendant convicted of a second or subsequent offense for DWI who seeks a step down in sentence on the grounds that one or more of the prior convictions wasn't counseled must first petition the post-conviction relief in the municipal court in which the prior uncounseled conviction occurred. The PCR proceedings in municipal court are governed by Rule 1:10-2. For additional information on these matters, contact the Law Office of Kenneth Vercammen, 732-572-0500, on the web at www.njlaws.com, that's njlaws.com, also benotguilty.com, that's benotguilty.com. We're at 205 through Woodbridge Avenue, Edison, New Jersey. In our next edition, we'll talk about additional recent cases that were discussed at the seminar handling DWI, drug, and serious motor vehicle violations. Thank you, and good luck.